It's important that everybody have realistic expectations about how long this is going to take. So I want to kind of walk through with you what the timeline looks like or starting to look like on these cases and what you can expect once we get started. So the initial phase is a demand letter. Every state requires that you send a demand to the defendant previous to filing suit or filing for arbitration so that they have a fair opportunity to settle the case without going to court or arbitration. And if you don't do that and you just haul off and file the arbitration, then you're not allowed to recover your attorney's fees. So we have to send the demand letters. The longest requirement of any state is 60 days. So all of our demand letters go out with the 60-day demand. So there's 2 months. At the end of 2 months, generally they don't respond, and we pretty shortly thereafter file the arbitration. So we draft the demand in arbitration, we file it, we pay the filing fee, and we serve the other side. That takes a week or two. Then we wait. And the organizations that administer the arbitrations, the AAA and JAMS, they send the defendant a notice that says, hey, here's your invoice, pay your fees. And the defendants have figured out that they can buy 90 to 120 more days just by not paying the fees. And the organizations are loath to dismiss the case because then they get no money, and they don't want to push too hard because then they get no money. So we wind up sitting in a spot where it was 2 months before we filed the arbitration, and then it's 3 or 4 months after we filed the arbitration that the defendants then pony up at the last minute and they pay the filing fee, and then they go through the process of appointing an arbitrator. That takes almost 30 days because they have a list that they give you of a potential panel of arbitrators. And then we go through this process of ranking who we like and all that. And then they appoint an arbitrator. And then after that, within 30 days after that, we'll have what they call the initial scheduling conference. And that is then when everything really, really gets started. And that is when the judge sets the trial date, tells us when we have to have all our documents to the other side, and they have to have their documents to us, what depositions we need to do. All of that gets done at that scheduling conference. And it is at that time you'll know what your trial date is. So 2 months before we file, a month after we file to get the arbitrator. Wait, I take that back. It's 2 months when we send the letter, and then we file it. I say just a couple of weeks. Let's ignore that. Let's just say we immediately file it. Then it's like 3 months before the other side is forced to pay the filing fee. So now we're at 5. It takes 30 days to get the arbitrator. That's 6. And then probably another 30 days to schedule and have the initial scheduling conference. So that's 7. And then the arbitrators that are right now, they're setting the trial dates between 90 and 180 days. So that's another 3 to 6 months. So we're looking at 13 to 16 months to get this over with. So that doesn't mean that nothing's happening or that we're not doing anything. We're just doing everything we can. And then it gets really busy after the arbitrator gets involved, because then we got to get our evidence, we got to get our documents, we got to get our witnesses, we got to do all that. So it's going to be months and months of boredom interrupted by a few months of sheer terror. But we'll get it done. And that's what we do. And that's what we thrive on. And we will love to do it. You're going to hear from us more than you want to at the end. And right now at the early phases, you might not hear from us as much as you'd like to, but I promise we're doing what we need to do and we're moving the process along.